I had to write out my warfare prayer list. So I have my notes, and I do my prayer, and then I put it in front of me, and then I speak it out. Daily, I had to plead the blood over, Sandwich and her minions, many ex-Shekinah church members, specifically put out Wilkins family and family members of other current Shekinah church members.
Hi, besties. It's Katie from Without a Crystal Ball. I cannot believe this. I am so excited. I can't believe this. I'm so happy. I might lose my mind. I cannot believe this. This has been going on for like 3 years, and I'm shaking because in June, I was like a little bit upset because Robert Shin of Shekinah Church, who is a pastor of this group of people, and he was the man featured in the Netflix series Dancing for the Devil, the 7M TikTok cult. Well, while we were making this series, he decided to sue a bunch of us, including me. And this lawsuit's been going on forever. And we filed a summary judgment in January. And based on how discovery went and how we didn't get anything in discovery, how he didn't provide us any evidence of damages and his deposition and just all of it, we were almost confident that there was no way that it would survive a summary judgment. And so we were shocked when the judge ruled and denied part of it and said that there were aspects of this case that needed to go to trial. And the minute we got this back, I sat down with my legal team to figure out what we were going to do, and everyone believed that they got it wrong. The facts are this complaint that he had filed is filled with so many different statements. It has so many different allegations, and it's just completely all over the place. And since the complaint was filed, and since even our summary judgment was filed, there's been all these new videos that have come out of audio of him saying things that all but confirm everything that I've reported. And the Netflix series literally confirms what I reported. And it was frustrating because I live in a state where there's no such thing as anti-SLAPP. There's no shield law for attorneys or for journalists. And the shield law that we have is nothing like what they have in New York or California. We have no protection. And so it's like the best place for people to sue because they can just sue you and you can be stuck in court for 3 years. So my attorneys did this amazing thing, and they filed what's called a motion for consideration. And at the time, I had no idea really what she was looking for or what she planned to tell the court or what they got wrong because I was so disheartened by the ruling itself. So I got notice today from my attorney that the court granted our motion for reconsideration. And I am shaking right now because this means that the court really likely got it wrong. And it's likely that this case could get completely tossed. And I don't want to get ahead of myself, but let me explain to you what my attorney sent to the court. I'll read it to you. Um, Jennifer Moore, she's my attorney. She's also representing me with Blake Lively. She wrote, pursuant to the Minnesota General Rules of Practice, defendants respectfully request permission to file a motion to reconsider the court's June 23, 25 order denying in part their motion for summary judgment. Compelling circumstances warrant reconsideration based on clear legal errors involving fundamental First Amendment protections that are dispositive of plaintiffs' claims. I love my attorney because she's like a staunch defender of freedom of speech, and she's such like a advocate for me, and she loves doing this kind of work. So I'm going to get teary-eyed. The court erred by treating protected opinion as actionable fact. The court's order commits a fundamental error by concluding that Ms. Paulson's commentary and use of hashtags could be found defamatory. The First Amendment's protection of free speech rests on the principle that under the First Amendment, there is no such thing as a false idea. The order finds a jury question exists because Ms. Paulson, after stating her opinions, usually follows up these posts with hashtags referring to trafficking, human trafficking, trafficking, cults, and forced labor. This reasoning reveals a critical legal error. The court failed to conduct the required threshold analysis of whether the hashtags themselves constitute protected opinion. The determination of whether a statement is protected opinion is a question of law for the court, holding that only statements that are provably false are actionable. Instead, the order conflates these two distinct inquiries. Characterizing a group as a cult is a classic example of non-actionable opinion. In the fast-paced, abbreviated context of social media, hashtags like trafficking function as a rhetorical shorthand to frame a topic of public concern, here alleged exploitation, not as meticulously drafted criminal accusations. Such rhetorical hyperbole is not actionable. The court's failure to perform its gatekeeping duty on this question of law is compelling reason for reconsideration. The court misapplied the actual malice standard. The order correctly identifies that plaintiffs are public figures, but then misapplies the actual malice standard. For public figures, the plaintiffs must prove that the defendant acted with knowledge of falsity or reckless disregard for the truth. At summary judgment, the plaintiff must come forward with clear and convincing evidence from which a jury could find actual malice. The order bases its finding of a triable issue almost exclusively on the fact that plaintiffs disputed the truth of Ms. Paulson's statements in their depositions. This reduces the constitutional standard to a common law credibility contest. A public figure cannot defeat summary judgment simply by saying that's not true. They must present affirmative evidence that the journalist subjectively entertained serious doubts as to the truth. The order identifies no such evidence, thereby improperly shifting the constitutional burden to the defendant journalist. And then finally, the court failed to recognize that boycott advocacy is a constitutionally protected justification for tortious interference. The order fails to address a dispositive constitutional defense to the plaintiff's tortious interference claims. The court found as fact that Ms. Paulson encouraged people to boycott plaintiffs. Speech advocating for consumer boycott on a matter of public concern is constitutionally protective and cannot form the basis of a tort claim. The order states that whether Ms. Paulson alleged interference was justified is a factual issue to be decided by the jury. While justification may be a fact under this law, the existence of a constitutional justification is a question of law for the court, establishing the court's duty of independent review on constitutional facts. This oversight and outcome determinative for counts 3 and 8 and constitute a compelling circumstance for reconsideration. These errors fundamentally misapply controlling precedent. We respectfully request permission to file a motion for reconsideration. So all that is to say that they ruled on things that from the precedent that's already been set in our country and in the state of Minnesota is in opposite. So like they were trying to say that calling something a cult is actionable, but the state of Minnesota has already applied that calling someone a church a cult is like an opinion. And then with the boycott aspect, I mean, can you imagine if you got sued and you said, if you don't want to like buy their products, you can boycott them? Or like if you're watching the stuff with Blake Lively and Ryan Reynolds, think of it this way. Like, can you imagine if you were like, we need to boycott watching their movies and then they sued you for interfering in their contract? It's wild. So I didn't know how it was going to go. And then this is what the judge said today. The above entitled matter came before the Honorable Carrie Willis for an in-chambers review of defendant's correspondent requesting permission to file a motion to reconsider the court's June 23, 2025 order granting in part and denying in part. Whereas plaintiff filed correspondence opposing the defendant's request, and whereas pursuant to Minnesota rules of general practice, motions to reconsider shall be granted only upon a showing of compelling circumstances. And whereas the court finds that compelling circumstances to file a motion to reconsider do exist, including in part the extensive litigation history of this case, the complexity of the legal issues presented to the court, and the voluminous allegations in the complaint, and the importance of accuracy and clarity regarding the court's ruling. I'm shaking. Do you remember how I told you with the Blake Lively case that narcissistic people have this tendency to like overwhelm judges and they create these complaints that have so many complex situations happening at the same time, and there's like chaos within the complaint that you can't even tease through what happens, and then they paint you as the dangerous one? This is what has been done to me for like the last 3 years. I have been painted to the judge as though I'm dangerous, that I'm vindictive, that I'm doing this maliciously, that I hate people that are Christians, and that I completely just made up what happened. And one of the biggest problems here is that some of their actionable things that are left are literally me reporting from a public record or a court record, or somebody sharing with me and then me posting what they said. So, one of their claims that the court completely ignored was that this they had a contract with the LA Clippers. I had nothing to do with the LA Clippers contract, and all I did was posted on my Instagram that somebody else had contacted the Clippers and let them know what was going on in this church, and that there was concern for the people involved. So it was a matter of public concern. And I didn't contact the Clippers. I didn't even call for people to contact the Clippers. Like, I got the message from someone and then I posted it that they did this, right? And that's what the outcome was. And he's to this day trying to tell the court that no, I was the one that contacted the LA Clippers, and I told people to contact the LA Clippers and I didn't. That's one part that really frustrated me about the order, because I was like, I had nothing to do with the LA Clippers. And I also didn't directly tell people to boycott anyone. I simply stated, like, if you don't want to support what's happening here, and if you believe the people that have left that this is what's going on, you cannot support them, which again is a right that if there's a matter of public concern, you have the opportunity, any consumer can decide to pull and boycott a product based on matters of public interest and concern. And then another issue had to do with the trafficking, because I published a statement by one of the siblings of a man that was within this group, and the sibling told me that they believed their brother was being trafficked, labor trafficked. So we did a post where she shared her belief of what was going on, why she came to this conclusion. We cross referenced it to all these different lawsuit issues he's had and wage claim issues that he's had. And that somehow is me saying that he's trafficking them, even though all I did was report it. And the Netflix series brings up the same issues with the trafficking. So again, it kind of begs the question that just because you talk about it doesn't mean like, and you're reporting on it, you're not the one making the accusation. I'm not the one making the accusation. The people involved were the ones making the accusation. And I'm just saying, this is what they're saying. This is what the lawsuits have been. This is what the parents are saying. And then when it comes to the malice, oh my God, this part made me so upset, you guys, because do you remember how I said that like people will lie when it comes to depositions? And when I was telling you about why Blake is probably not trying to sit for hers, is because all three of them sat in their chairs, and it's my opinion they lied. And their only counter for things that I reported on was that's not true. But then they provided us no evidence to show that it wasn't true. And they had no counter for the evidence that we provided of what people said happened, their receipts, quote unquote, and the lawsuits that were being filed against him for this. And the court just ignored all of it. It was so frustrating. So I'm just really glad that this is going to be reconsidered and they can hammer out these last issues, and hopefully this will be the end, because the thought of having to go to trial with this man makes me want to pull my hair out, honestly. So if you want to know why narcissists get wins in court, it's because they confuse the judge. They overwhelm them with information. They overwhelm the complaint. They make and paint the person that's on the receiving end, the defendant, look crazy and unhinged and dangerous. And the reality is me in my lawsuit, I'm being treated the same way that Blake is treating Baldoni and everyone else. They get rulings that are awesome because they confuse the judges. And sometimes judges admit that they got it wrong. So hopefully in this case, we can figure out how to get rid of these final claims and be done with this case for good. Because this case has, and this lawsuit has always been frivolous from day one. I don't report with malice. I report everything in good faith and from public records and from eyewitness accounts and people directly involved. So yay! I'll keep you up to date about this, but this was a big win for me. I haven't had a lot of wins in this case, so I'm feeling really, really hopeful for the first time in a long time. So yeah, thank you guys. Let me know what your thoughts are in the comments below. And make sure to subscribe to my channel and give this video a thumbs up. Bye, besties.